Kerry, you've got your hand up. Are you okay?
Yes, thank you. Inspector, I've been told that Sean Griffiths is not attending this afternoon.
Thank you very much. Okay, I'll just, while we're waiting, I'll update my list. That's very kind. Thanks.
Thank you.
Thank you. Right, good afternoon. It's 2 o'clock on my system, so time to reopen these virtual hearings into the North Warwickshire local plan, the third set of hearings so far. Can I just check, first and foremost, can everyone see and hear me? I will take silence as a yes. Okay, thank you all for being here, for your contributions and for your patience in the event that there are any hiccups in this virtual format. Now, many of you, I'm just looking, a lot of familiar names, many of you will be familiar with proceedings. We're aiming to basically replicate as closely as possible a physical hearing in virtual form. And I know many of you were in the introductory session on Tuesday morning, which was slightly fuller than I'm going to give an introduction here. Excuse me. Nevertheless, just a few points. I'm Tom Bristow, the Secretary of, I've said that before, I'm the Inspector appointed by the Secretary of State to conduct the examination and ultimately to prepare a report with the recommendations to the Council. Today, this afternoon, the discussion will be structured around paragraphs 45 to 55 of examination document INSP 5B, which is the which I'm taking as the agenda and the rough matters, issues and questions for discussion at this stage. Now, I'll try and avoid any acronyms, but where I do say things like that, like INSP 5B, they're generally examination documents hosted on the examination website. That is maintained by Kerry Truman, the Programme Officer, who's on the line and who's the first port of call for all inquiries, and that's hosted on the Council's website. The other acronym I'm going to use extensively is the NPPF. And when I talk about that, it's the 2012 version of the NPPF, rather than the subsequent version. There were versions published in 2018 and 2019. But the principal approach here we're going on is the NPPF 2012, although we may touch on later versions insofar as they are relevant. The other key document we'll be referring to, and it may be useful to have the examination library and these documents open in front of you, is the latest schedule of main modifications, which is NWBC 20E on the examination library. And please do interrupt me or interject or raise your hand if anything I say is unclear or it needs would benefit from further explanation. So guidance is on the examination website also in terms of data handling, privacy and virtual hearings. Those documents are INSP 22, INSP 23 and INSP 24, and I would encourage everyone to look at them if they have not yet done so. The format of the hearing will be an informal discussion led by me on specific matters. I will generally summarise what I see to be the key issues that we need further discussion on, and then invite comments from various parties, of course, giving the council opportunities to comment, given that it is their plan that I'm looking at. I've asked this in all other sessions and the answer has never been yes, but just to check, has anyone joined us via phone as opposed to using Microsoft Teams directly? Not hearing anything. That keeps things simpler as the controls are slightly different in that respect. Just to say that all questions, if you want to raise a question, they should be put to me in the first instance rather than any form of sort of cross-examination. I may then, of course, pass them on to a party to comment on, but then once you've made that question to me, I'll determine what or whether further discussion is necessary. In terms of data privacy also, this hearing session is being live streamed on the council's YouTube channel. It's also being recorded on Teams for posterity and will be retained in line with those data privacy policies until and shortly after, when ultimately my report is with the council. In that, with that in mind, just be careful not to share any personal information, whether that's yours or other people's personal information, whether that's verbally or by showing things to the camera, etc. As everyone has done, you may wish to turn your camera off during proceedings and then to appear magically when it's when you want to speak. It's also very convenient, as I think everyone has done, to put your microphones on mute to minimise interference. But just do let me know who you are when you speak. I intend to have a short break. Well, the agenda and timings are quite flexible. I'm not entirely sure how whether we'll need much of a break or how far we'll go, but we'll see. But we are scheduled to go till roughly 5. I'll probably have a break in about an hour and a half's time, just so we can kind of gather our thoughts, but we'll see. During any breaks, any intermissions, don't leave the meeting. The recording will keep going. Just keep your video off and microphone on mute. Now, oh yes, I should also mention that you can hang up at any point, so you can disconnect at any point if you've said your piece, if you've had enough of the discussion. Kerry, the program officer, and of course the councillor there to let you back in if for whatever reason a connection drops out or you accidentally press the leave button. If you wish to speak or contribute, if you could please use the raise hand function in Microsoft Teams, which is the palm symbol. I'm sure many of you will be familiar with that. And remember, if possible, to unraise your hand once you've made your point, so it doesn't look like I'm picking on you. I will get round to you, perhaps not immediately, though. I may, from time to time, share some documents, as I've done in previous sessions, by way of the share screen function. So I was looking at that. It doesn't seem I can today, but that's not a problem. I wasn't intending on, but generally we won't be using that function. We also won't be using the chat function in Microsoft Teams. If anyone there does. Someone has just made me a presenter. That's very kind. If anyone does use that chat function, I'm afraid I won't be looking at that. You may see, as you've probably seen already, that I'll be looking around occasionally to find documents, write notes, and what have you. Don't be offended if while you're speaking I'm looking elsewhere, writing something down. I am always listening. As I've mentioned in other sessions as well, there may, of course, be technical issues to do with virtual hearing, bandwidth and the like. I'm sure we can get through them as we have previously. In terms of the substance of our discussion, generally speaking, all information, all evidence, documents and the like should already be in front of me and should already be on the examination library. In that respect, it may be useful to have the 2012 version of the NPPF in front of you. I'll be looking particularly at the tests in paragraph 182 of that, which deals with soundness. Given the time at examination of the plan and the number of documents that are there on the examination library, it may not be necessary to cover each and every matter that I've set out. And with that in mind, if I could ask everyone, as everyone has done in previous sessions, to keep contributions as succinct as possible, that would be fantastic. I may, on occasion, stop you if I've heard enough, if I'm already well aware of the issues, or if I feel like nothing new particularly is being raised. Don't take offence at that. It's just simply the way things are at this stage of the examination. Part of the process I'll just explain is exploring, clarifying the issues, getting clarity on certain matters rather than giving a particular finding here and now, although I will try and be as open with what I'm thinking as possible, including identifying any actions or potential main modifications that I may see as necessary. I'm keeping a list of those. I think from this morning's session, I'll just have a look. I've got 7 actions or potential alterations to main modifications. We'll have a sort of administrative or wash-up session at the end of this afternoon where I'll read through those and we can discuss if they're kind of comprehensive and when things are due by, etc. The examination, I would just point out, only concludes when my report is with the council, and there will be further opportunity for comment on potential main modifications. Those are going to be the subject of this particular discussion on Thursday afternoon, although we will touch on some in the course of this session, I'm sure. So before we turn to paragraph 45 of INSP 5B, are there any questions at this stage, whether that is in respect of how we're going to organise the hearing, any of the functions on Teams, anything to do with the agendas? Any questions at this stage? Okay. Then I will go on to do a roll call. The reason I'm looking at this side of the screen is that I can see 10 or so attendees, but I think this is a useful part of the process just to make sure I know who's here and if anyone is here that I wasn't necessarily expecting, and also to check that everyone's system works. So if I just do a roll call looking through the attendee list that I have, just if you could indulge me and say yes if indeed you're here. So from the council, I have Mrs. Barrett, Mr. Dittman and Mrs. Wilson.
Yes, sir. All 3 of us are here.
Thank you. Thanks. Then I have Mr. Austin Fell.
Thank you, sir. Here.
Thank you. Michael Davies.
I'm here, sir.
Thank you. David Hodgetts.
Yes, I'm here.
And are you here on your own, or have we got Edward and Mr. Han?
Edward here, sir.
Okay, excellent. And Doug Han, are you here as well?
Yes, I'm here, sir.
Okay, thank you. And Jeremy Smith?
Yes, sir.
Okay, thank you. Now, have we got Victoria Lane?
Yes, sir.
Thank you. And Kerry mentioned earlier that Sian Griffiths is not attending. Mark Sitch.
Yes, sir. Good afternoon.
Good afternoon. And Mark Bassett.
Yes, sir. Good afternoon.
Thank you very much. Now, is there anyone here whose name I haven't called out? Okay. Good. Right, let's turn to paragraph 45 of INSP 5B. Now, who did I have down against this? Let me double check my notes. I had Mr. Bassett, I believe, from HLM. Should the supporting text at paragraph 7.32 of the plan be amended to accurately reflect the purpose of the meaningful gap or strategic gap? And that is quite a lengthy question, but also relates to potential main modification 25, which I'll just get in front of me. Okay. Now, I believe that's a point made by Mr. Bassett. I may have got that down incorrectly, but Mr. Bassett, would you like to talk to that point at all?
Yeah. Yes, just briefly. So yeah,
Thank you.
That is the point raised. It was just one of consistency really between the amended drafting of the policy through the potential main modification and that of the supporting text. And I think at the supporting text it still talks about it should not be physically reducing the size of the gap, whereas that seems to have been sort of taken out of the policy itself, and it's just making sure that those two points were consistent, really.
I see. Thank you. Let's go to Mrs. Barrett on that point. It's the sort of consistency now of the text supporting the strategic gap policy relative to the phrasing in potential main modification 25. Oh, sorry, Mr. Dittman, did you want to come in on that? We will talk in point 46, which is point 46 of INSP 5B, which is fundamentally linked, which is the sort of the purposes of the strategic gap or meaningful gap as it was formerly. But on that particular point.
Yes, sir. Thank you. It was just really myself rather than Dorothy on this particular issue.
Oh, I'm sorry.
No, that's okay. It's just yes, we're willing to look at the 7.32 to be amended, and I'm happy to take that point from Mr. Bassett. Yes, we have in the main mods 25 dropped that particular reference, so we are happy to reflect 7.32 with a further amendment, and we will be doing that because we are doing some further amendments to Amendment 25.
Thank you very much. Now, I'm not. That's a helpful clarification, Mr. Zimmerman. I didn't see whose hand went up first, so let me deal with Mr. Smith and then Mr. Hodges. Mr. Smith.
Sir, I've got a point. I don't know whether you want to deal with it now or whether you'd like to deal with it under your paragraph 46. It's a broader point about the functionality of the gap, and obviously this then reflects on 7.32. So
yeah, well, let's hear that now, because that was my next question, and I think the 45, provided that satisfies what Mr. Bassett wanted to mention, I saw that as more of a sort of a point around clarity rather than of fundamental purpose, which I suspect, Mr. Smith, that's what you're going to talk about. So that was the next point in order, so I'm happy to deal with that now.
Thank you, sir. Yeah, that is very much what I would like to address. I think that my concern with both LP5 and 7.32 as they stand is that they hinge on a visual or physical reduction in the gap. And so, put simply, it would be possible to have a physical reduction in the size of a gap, and that gap could still be entirely functional. So the physical reduction in the size of a gap isn't actually a measure of a reduction in its effectiveness. It is possible that the remaining land, for various reasons, could be incredibly functional. Likewise, it is possible to have two settlements which are indivisible, which you can see across a gap, but you still have a very strong sense of separation because of the nature of the land in between those edges. So if the objective, as 7.32 starts to say, if the objective is to retain the separate identity of these settlements, then I think you have to look beyond purely physical separation and visual separation. And so that's where I say in my note that there are a number of other factors which I think need to be considered. I don't know whether you want me to touch on those now.
I think perhaps, and I certainly see the logic of what you're saying, and in terms of some of the guidance that's out there about how you undertake, for example, landscape and visual impact appraisals and that sort of thing. I can understand that. What I suppose what I would say is how in your mind, from your perspective, could that policy, could LP5 be made sound, if that makes any sense? So how via potential main modification, because we talked about one that applies, how could that be articulated in the policy?
I think the policy should say that all new development should not significantly undermine the sense of separation between and separate identities of the settlements. And the wording there, the sense of separation and separate identities, covers the range of different factors which need to be considered, rather than just hanging our hat on physical separation or visibility. So in many ways it would, the simple fact is that all of the land that sits in between settlements, some of that land is more functional than others. So the reality, and some of those parts of those of that gap will also be visually more important as well. So to be honest with you, it would have to be addressed on a case-by-case basis. There is, for example, some development that could take place that wouldn't actually undermine the functionality of the gap. And likewise, on a sort of a local plan by local plan basis, you'd need to review where you are with that gap, how it works, and what could potentially go on in that gap that wouldn't undermine the functionality, the identity of the settlements. So to me, I think it's about a sense of separation is where we need to go, and that seems to be where other authorities are driving their policies at the moment.
Okay, thank you. Yeah, no, I mean, I absolutely take those points, understand the logic. In terms of monitoring indicators, I think this is a point. I think this was a point raised in your representation to the additional local plan consultation, but apologies if it wasn't. The amount of land lost from the meaningful or strategic gap was, in your view, too crude a metric, or in someone's view, too crude a metric for actually the functioning of that policy. Presumably, in what you're saying, the importance of a sense of separation is inherently qualitative rather than something that can be reduced to quantitative measures. Is that right, Mr. Smith?
No, that's absolutely right, sir, because the reality is that I work on a lot of sites in gaps, sometimes 150 metres wide, sometimes several kilometres wide. The reality is there is no absolute measure. And as I said, there are parts of gaps that are much more functional than other parts. So the truth is it varies site by site. It varies development by development as to what would be acceptable. The point is, what matters is that we retain the functionality of that gap and that it retains the separate identity of the settlements. So I think that what a lot of other authorities are doing now is they're pointing at the sort of factors, for example, the sense of leaving one settlement, travelling through an intermediate space, arriving somewhere else. They're putting that in the supporting text and then saying within the policy, it's about that sense of separation and the separate identities of the settlements. But it is, as you say, sir, it is something that's much more qualitative, very difficult to quantify.
Okay. Well, no, that's very helpful. I mean, I think yes, there's a kind of there's a thought process that's revolving in my mind as to paragraph 154 of the MPPF as clarity in terms of decision taking, but there's the other dimension that there are a number of factors and how you measure that. So I very much see those points. Mr. Hodgetts, I saw your hand was up. Was there something you wanted to add to that, or else I will return to the council. Thank you, Mr. Smith, for any comments on those views, which in summary I took to be that so far we've got to a point, having reviewed the evidence, and I should make clear that when the world was slightly more normal, I did go to have a look, and I remember in the previous session there was, I say previous, this was some months ago, but there was some discussion about the point Mr. Smith raised of different elements of the proposed strategic gap performing different functions or relatively strongly against those purposes. And I remember a discussion between parcels 7 and 8 in particular, which I went to have a look at. So I am relatively well aware of that area. But Mr. Hodgetts, did you want to add anything to what Mr. Smith was saying, or shall I ask the council for some comments?
So my point was actually unrelated. It was related to paragraph 7.32, and it was I appreciate the conversation's come a long way since then, but it was just simply that is a case of as well as being it has to be consistent with the policy. There's an element of repetition there, and whether it's actually needed at all. But I appreciate now the council have agreed to go away and look at that, and perhaps what they come back with will avoid that repetition as well. But anyway, feel free to continue and put the points to the council as you.
Okay. Yes. No, I see that point on 732. Okay, Mr. Dittman, or indeed Mrs. Barrett.
Thank you, sir.
Any comments about the point of potentially changing how the strategic gap or meaningful gap policy operates to make it more focused on the sense of separation as opposed to the visual dimension, which is where we've currently come to in terms of the potential main modifications? Thank you, sir.
Just to confirm, I do appreciate and understand the direction Mr. Smith is coming from in terms of how you apply what is effectively, in many situations, quite a subjective application of terms, and how different developers, individual local authorities, or inspectors even interpret those terms. Because, of course, as we have immediately south of the A5, a classic example through the St Modwen's appeal of the interpretation of whether a gap existed, for example. So we do understand the concerns about the terminology, but there is still a concern from the authority that if we were to just to use the term sense and little else, that might leave it far too open to subjectivity, and we would still like, whether you call it a criteria or a category or an element-based additional references within the policy. We have discussed this with our DC colleagues, and as you see, you do have the current main modifications 25 in plan, but we've also looked at this idea of widening the interpretation using the points raised by Mr. Smith, using the term sense. We have come to some further thoughts where the sort of criteria we still want to try and retain within the policy, if we can, is in relation to development proposals that won't be permitted where they significantly affect the integrity of the gap, perhaps rather than the actual physical size, so affecting the integrity of the gap. The physical and visual separation of these settlements, which we still do feel is important, and members will particularly note that, though I do take on board Mr. Smith's comment about it will differ on different sites, because we do have other appeals where we have won and lost, as we have at Pooley Lane. But also, going back to the earlier comments on how some other authorities have tried to focus the policy, which is where one of the main points we're trying to do is to prevent the settlement's coalescence and maintain not just the physical separation of those settlements, but their respective distinctive characters. And we just felt that just using the term sense, perhaps, it leaves it too open, and in some circumstances, and I to some extent will rely on the other attendees' knowledge or lack of knowledge on the particular locations. Using the idea, as Mr. Smith said, of you going from one settlement to another, that will differ quite significantly in certain parts of this particular strategic gap. The A5 route particularly, I think, is very, very robustly obvious as you come across junction 10 from a roundabout into an open area. And then there's that immediate gap to your left, obviously no longer to the right, but to the left before you reach Dordon. You have slightly different situations coming from the Tamworth direction on the B5000, where due to some more mixed development situations and uses, there can be arguments made, but there is still a clear release, for want of a better word, as you come out of Tamworth into a more open and visually different environment or character. And it's how the policy would best reflect that. And yes, there are elements that there may be for accommodating some development that doesn't affect those particular categories, but we would like that references to those categories to be within the policy, rather than leaving it so open and subjective that, depending on the circumstance of the case, we could have quite differing arbitrary decisions made because there isn't that perhaps clearer focus on which elements of the categories that create the gap should be concentrated. Does that make sense, sir? So
yes. No. I mean, I very much see your point. And while you were saying that, I was looking through the various provisions of MM25, potential MM25 as we have them, and I appreciate the point that we're dealing with a plan, but that plan will. Oh, I saw a bit of a lag. Sorry, there was a bit of a lag in the connection, but that plan will ultimately inform decision taking, and it's that balance between how far you go at a plan level and what ultimately rests to be tuttled out in terms of decisions. What I would ask, and I know there have been a number of hands that have gone up, and this is probably one for Mr. Smith to reflect on. My reading of MM25 in relation to LP5 at the moment is not solely that it is a visual consideration. So category 2, any development must respect the separate identities. That is not solely a visual thing. And development should not significantly reduce the visual separation between Polesworth with Dordon and Tamworth. That to me equally sounds like there are things that may affect the separation but not significantly, and may therefore be acceptable, but doesn't indicate that that is the only consideration. So I suppose my challenge would be, is actually what you're asking for in MM25 and LP5 already there, albeit not explicitly set out? So perhaps that's a little bit of a mean question, but I will come to Mr. Smith, and then I saw yes, Mr. Hand's hand up. So, Mr. Smith.
Yeah, thank you, sir. Yeah, it is a mean question.
Sorry about that.
The problem with reduce the visual separation. Let's think about what that actually could mean. What do we define as visual separation? Does that mean that if you can see the edges of the two settlements, either from the middle of the gap or from either side of the gap, does that mean that that gap is any less functional? And there are literally hundreds, many of gaps between settlements where you can see between those settlements. So, and that doesn't mean that there isn't a functional gap between them. So the problem I see, sir, is that is open to one, it's open to a lot of interpretations of what visual separation actually means. And two, of course, I think it misses the fundamental point. And it was interesting hearing the council explaining there what they wanted to achieve. And they said, look, you leave the settlement, you enter the countryside, you have a clear sense of being somewhere else. And I think the interesting thing is when we start talking about gaps, we start using those terms. I know that I'm leaving the settlement. I know I'm entering the countryside. I know I'm arriving somewhere else. And I think, so it's interesting in that context that with, for example, Basingstoke and Dean, what they do, they have supporting text, which says, when travelling through a strategic gap, and this is in my note, by the way, when travelling through a strategic gap, a traveller should have a clear sense of having left the first settlement, having travelled through an undeveloped area, and then entering the second settlement. So that's in the supporting text. So that's where they explain exactly what they want the gap to do. And then you could have a policy which actually, and the council started to say this, a policy which says don't significantly undermine the integrity of the gap or the separate identities of the settlements. So to me, those two together would work very well. So if you understand, first of all, that you're trying to protect the separate identities of the settlements and the integrity of the gap, and then you have an explanatory paragraph behind that that says this is really what we're trying to do. And if you think about it, you can't, that does absolutely safeguard the nature of the gap, because it's not just about sensing that you're leaving somewhere. You've got to travel through a space and arrive somewhere else.
Okay. Yes, I see that. I mean, I suppose the question really is one for me, given that criterion 2, as we have it, says must respect the separate identities. And that, to me, in perhaps a simple understanding, gets to the heart of what that policy seeks to do. And I suppose my concern is with adopting a word like sense is that, and you mentioned, Mr. Smith, the visual separation in itself, which is presumably an aspect of sense, is subject to various debates. Then sense may be subject to even more debates. That's what I'm tussling with in my mind. Mr. Dittman, can I hear from you on that, please?
Thank you, sir. Yes, I do take that point, but I just wanted to respond very, very briefly to Mr. Smith. Yes, we are not against that suggestion of perhaps clarifying through the reasoned justification the sense or the visual separation criteria or clarification that might help the situation. So I'm happy to consider and accommodate that suggestion in the RJ to help give some explanatory background to the very points that Mr. Smith raised. This approach where you're leaving from one settlement to another, and that, if you want to put it in those terms, sense of going from one to another into the countryside. It was only a term I particularly made reference to, and use that perhaps to help support the policy. I don't know if that helps.
Mr. Smith, in your view, would some reasoned justification help in that respect?
I think yes, if it uses those sorts of terms, and I think it's always helpful in these cases because there's such a divergence of how gaps are dealt with across the country. It's really useful to try and follow some well-worn paths, and in this case, this growing body of evidence, this sort of trend, if you like, of following this sense of leaving a place going through an intermediate space and arriving somewhere else. I think that everyone understands what that means. You could, and I understand your reluctance to use the term sense, but I think if you had that in the background in the explanatory text, and then your LP5 dealt with purely not undermining the separate identity of settlements, then I think those two together would work. They would work well.
So I was just making a note of that. Okay. Well, it sounds like there's nothing between you and the council on that point. So I will put that on my list of actions, as I entirely see that the sort of the justification for a policy, the aims that it seeks to achieve, if expressed in the clearest possible terms, maximizes the effectiveness of a plan and minimizes debates later down the line. So I see that point, and I think, Mr. Dittman, would you be okay to accept considering something to that effect in the reasoned justification for effectiveness of the plan?
Yes, we would, and it is something, particularly if Mr. Smith has specific examples, particularly more recent ones arising through other local plan, particularly inquiries, that would be helpful. If obviously, Mr. Smith, if that's okay with yourself, if you have that information available, and if you could forward it through the programme officer, that would be appreciated.
I have no problem with that at all, and I will do so. Yeah.
Thank you very much. It's very collaborative. Great. Now, Mr. Han, I saw your hand was up. I'm sorry if I've bumped anyone else out of the queue, but that's who I saw first. So, Mr. Han, anything you'd like to raise?
Only a small point. It was just insofar as the way the policy, thinking about how it would be applied and of that. It was, I think, a lot of the council's comments that Mr. Dittman's just talked through probably address the concerns I had, that quite often strategic gap or greenback policies are seen as in effect green belt. But I think and that was, I think, our concern, that reduction of gap is effectively creating a policy that's as stringent as green belt policy. But I think the clarification we just talked through now does move in the direction of confirming that isn't the case, that this isn't seen as a greenbelt restriction policy. Rather, it's to do with maintaining the identities of the settlements and the understanding of leaving one place and arriving in another place. So I think that discussion just now has sort of given me comfort that the policy is conceived in a way as not to be a limit on any form of development, but more to serve the purpose of maintaining the identities of the settlement. So that was the point I wanted to make. So I think the debate has moved it forward.
And that's a helpful reminder, Mr. Han, that in previous sessions we considered the justification, the evidence there in support of the strategic or meaningful gap and its relationship to Greenbelt. That's just a kind of helpful reminder, and I'll just mention that in case people weren't here. But on the back of that, that is what led to a revised criterion 3. But I see your point, and I've noted it, that some justification underlying that, as we have previously talked about, may give some comfort in terms of its objectives and therefore, by inference, its relationship to the green belt and the relative purposes that each serve. So, thank you for that.
Yes, I think that'll be helpful. So.
Thank you. Now. Next person up I saw was Mr. Austin Fell.
Thank you, sir. Just coming back briefly to the discussion had, I think the input of a reasoned justification here would be very helpful for understanding the actual purpose of the policy. What are we trying to achieve here in the context of the gap? And the approach suggested by Mr. Smith and welcomed by Mr. Dittman, I think is a positive way of framing the policy. The recognition of the identity of these settlements in terms of how we approach looking as stepping stones, entering one, leaving another, I think is vitally important for setting the context of the policy. I also agree with the Council's removal of Clause 3 of LP5 under MM22. I think that subverts any issues of whether or not the policy is positively prepared, one of the issues, sir, you will be looking at. Just reflecting on the discussions had this afternoon, I wonder the legitimacy of including clause 3 or point 3 of LP5 as suggested by the council. Now, if we're to read the current limbs of the policy, and if we're to take them in order of primacy, we first have the overall extent of the meaningful gap defined by the council, and I think you could perhaps identify that, sir, as being the most important component to look at the higher level of the scope. If we then take that one further, point 2, which remains unchanged, tells us that we're looking at the character and identity of Polesworth and Dordon and Tamworth respective to their own locations. The new clause that's been added by the council, as has just been debated, it talks here about the visual separation and the need to ensure that that is a component taken into account. I share Mr. Smith's concerns here that we're almost starting to get back into the discussions had previously, where we're talking about quantifiable amounts, and I think I would express caution about starting to use such metrics as part of the overall appraisal. It needs to be much more refined, looking at elements more holistically. And in that context, sir, I do wonder whether that clause 3 is actually needed, or whether the visual component of the policy is actually captured at point 2 in any event, which asks us to look at the characteristics of each of those settlements and the identities. Because no doubt, sir, there will be a number of other facets considered under the branch of that policy. So perhaps, sir, to remove the ambiguity associated with point 3, it might simply be better to remove it.
Yeah, no, I see that. I see that point, and thank you. That's a helpful run through. I think I disagree, simply because it goes back to the point I made earlier about to what extent and I'm just speaking my mind. I'm not giving a definitive finding, but it goes back to the extent to which a policy provides a clear approach for decision taking. And I can't get around the point in my mind, and correct me if I'm wrong in that, or you may be able to get around that point. But if something does significantly reduce the visual separation between Polesworth, Dordon and Tamworth, that would inherently affect their separate identities, would it not? And that is a very clear, or not very clear, but it is certainly a clearer measure than identities for a decision taker to take into account. Mr. Smith.
Sir, I'm sorry, but I think we fall back into the same conundrum, because what is visual separation? The reality is, you can, as I say, have visibility between the edges. You can have visibility from the middle of a gap towards both edges. Does that mean that there's any less of a perception of leaving one place, travelling through countryside, and arriving somewhere else? Not necessarily. So I'm cautioned, to be honest with you, against visual separation. I don't think, to be honest with you, there's no definition of visual separation. That's the first thing. There's no real precedent of how you would test visual separation. There's certainly lots of cases where, for example, if you apply GLIVIA 3 standard landscape and visual methodologies, you would talk about visual effects on character. So that's certainly accepted, that if you have a very prominent settlement edge, that could have an influence on the character of the intervening gap, but that doesn't mean to say that you still couldn't have a very strong sense of being in countryside when you're in the middle of that gap, even though you can see the settlement in the distance.
No, I see that point there. Thank you for that. Mr. Dittman.
Thank you, sir. It was just perhaps, I'll just lower my hand, combine an element in terms of that term visual separation, which I do note the comments of Mr. Smith. In some of our, as I said, you won't have seen these yet, but we were looking at potential further amendments. We did look at changing the text, perhaps, this is in relation to 3, combining it either with 2 or keeping it separate and saying something along the lines of where they significantly affect the integrity of the gap, the physical and visual separation of these elements, or their respective characters. whether that accommodated the concerns about the focus being wholly on physical and visual separation and the difficulty in terms of interpreting that. And that if you interpret it very narrowly, physical can be seen as that's the gap as it stands and it will never change. So we were hoping that wording where it's significantly affecting the integrity of the gap, the physical and visual separation of those settlements or their respective characters in order to prevent their coalescence, whether that wording would come some way to compromise.
Just read that again nice and slowly, please.
Sorry, sir.
Development should...
proposals will, well, as it's effectively a combined approach rather than having a three criterias, we've just gone for, in order to maintain the separate identity of Tamworth and Paulsworth with Dordon, a strategic gap is identified on the policies map in order to prevent their coalescence. Development proposals will not be permitted where they significantly affect the integrity of the gap, semicolon, sorry, the physical and visual separation of these settlements, or their respective distinctive characters. Now, I'm correct, that may not go far enough because it still retains those terms, the physical and visual separation, but with the RJ providing a little bit of clarification or justification, that might be an approach, and we would be happy to share that if necessary.
Well, I think, thank you, and I think we're getting to the point where I've heard, clearly understood both sides of the discussion. That does seem to move part way towards the perspective that Mr. Smith and Mr. Austin Fell were advocating. I think, as ever, the devil will be in the detail. So, as I have what you said, significantly affect the integrity of the gap, the physical and visual separation, or the
respective distinctive characters.
Distinctive characters. Okay, I'm going to go to Mr. Smith, and then anyone else who wants to talk to this, and then I think I'm reaching a saturation point on this. Mr. Smith.
Yeah, thank you, sir. I'll be brief. I thought that text was almost perfect. I thought it was very good, and it had some really important stuff in there about separate identities, integrity of the gap. The problem is it is still the physical and visual. And to be honest with you, with all of the other things that you've said in that, in terms of the separate identities, the integrity of the gap, with the supporting text as well, talking about what you're actually trying to achieve, then to be honest with you, I don't really understand what the value of the physical and visual separation is, given that there are, as I say, a lot of problems in trying to pin down how physical distance or how visual separation actually would affect the sense of separation between settlements. These are not the only factors, and we have to be very careful. It could be possible, in theory, to place developments that diminish the size of a gap or that are visible, but would still not undermine the sense of separation. So to me, all of the other things that Mr. Ditton has just said, I think were absolutely excellent, would be absolutely spot on. But that, to me, that still, I'm afraid, doesn't fit.
Thank you, Mr. Smith. Okay, I'll come back to you, Mr. Ditman, after I've heard from Mr. Bassett. Mr. Bassett.
Thank you, sir. Yeah, it was just a sort of point of clarification on the reference to the term physical again. I just wonder whether we're heading back towards an amendment that you've already sort of, or that's already been proposed, in that the sort of physical reduction in the size of the gap, I think, was sort of proposed to be sort of struck out of the policy previously on the ground that it was too rigid. And I don't know whether I may have missed it in terms of whether there's a qualification before the word, but it just seemed to me like we're heading back to something similar to the original policy in that particular respect.
Thank you, Mr. Bassett. And I think that reflects where I was coming from, in that it is inevitably a policy which has intricacies, which has potential interpretations, and the judgment I will have to make is whether it is sufficiently clear in terms of soundness. I would obviously like to arrive at a wording that everyone is happy with, but I don't know if that will be possible. But in any event, what I will do is put in, and that was high praise from Mr. Smith, that it was nearly perfect. I will put in my list of actions, Mr. Dittman, that if, as it sounds like you have done already, you could take a look at both MM35 and the reasoned justification for that. That would be very helpful when we come on to main modifications. On Thursday, we could talk about that if that's ready for then. If not, we can consider it in due course. And of course, I mentioned earlier, there will be an opportunity for further comment on any potential main modifications as and when those go out for consultation. I think, are you prepared to sign up to that? Can I pop you down for that on my list of actions, Mr. Dittman?
Yes, sir. We partly started with the potential changes to the policy already, but I hope we should get some RJ delivered as well.
Thank you, and please do. You mentioned potentially working with Mr. Smith if there are examples of similar approaches that have been undertaken elsewhere. Do that if that would be helpful.
Yes, sir. Thank you.
Okay, Mrs. Barrett.
It was just a point of clarification, sir. It's MM25, not MM35. Sorry, just to...
MM35 was this morning, wasn't it?
It was. So
it's MM25.
Yeah,
thank you very much. Yeah, I'll amend
so
my
everybody
notes.
knows, no problem.
Okay, thank you. And Mr. Bassett, you have your hand. I don't know if that is a legacy hand.
It is indeed, yes. Sorry.
Okay, no trouble. And Mr. Hodgetts.
Hi, sir. It's not actually related to the conversation. I've been having some technical issues at my end, and on about 8 occasions during the course of this conversation, I've had a screen pop up to say that there's a technical issue and something looks like something went wrong. We're trying to get back to you, get you back into the meeting, and key elements of the conversation I was unable to listen to and take on board. I just wanted to flag it up with you because it seems like everyone else managed to listen to the entirety of the conversation without issue. So if that's the case, then I'm sure Mr. Smith and Mr. Others have been able to get their points across as they saw fit, but certainly I haven't been able to do in this part of the process because and I've got videos evidence to prove it of the last 4 occasions of the 8 when this happened.
I'm sorry to hear that. Are there any points you want to raise immediately? Anything we can discuss, or I might be able to help recap, provided, of course, the connection is maintained?
Sure. I mean, one overarching point, which I know you discussed, the interplay with Greenbelt and the fact that originally North Warwickshire had sought to through the LUC report. I can't remember the reference off the top of my head, sir, but I can find it for you quite easily. Which is it assesses the whole of the meaningful gap against Test 2 of Greenbelt. I think that the interplay between that evidence base undertaken on that basis, the fact that a sense of separation and the way in which meaningful gaps are appraised, both for local plans, as we've highlighted numerous examples in Mr. Smith's notes, and also planning applications elsewhere in the country. shows that there's a difference between the evidence base which has underpinned this policy and the best practice, which is assessing against not just the Eastleigh tests, which includes visual separation, sense, quality of the countryside, all other myriad different, I would ask Mr. Smith to come in and help me on that one because he'll know them far better than I do. But if he feels the need to do so, but the difference between the evidence base and what the correct way of appraising locations such as this has led to this point now, where we've got a policy which also seeks to take those routes with the pure visual and physical aspects, rather than having a bit of work having been done at the outset, which is essentially a landscape and visual impact assessment of the whole gap, all of the tests which come into play having been assessed to underpin it. That's something that I've gleaned from the fragments that I've been able to. But anyway, if anyone else has also been having technical issues, I'd suggest that they raise them as well, because it'd be interesting to know whether it was just me, but hopefully not.
Okay, yes, hopefully not. I know Mrs. Barrett has her hand up, and fingers crossed. Yes, and that's a helpful reminder, actually, that if anyone does have technical issues, pop your hand up at the soonest opportunity so that we can make sure that either those are work to be resolved or we pause while the internet sorts itself out. I note that point in terms of the evidence base for the strategic or meaningful gap, as it was in the plan, as submitted, and that's something I've given careful consideration to. I know you've referenced an appeal to the south of Junction 10 in that context, and I mentioned earlier, I hope you heard that I have been on a visit around that area. I see also your points about the Eastleigh tests and the sorry, that's the is it a strategic gap in the borough of Eastleigh? I note that point. What perhaps you didn't hear was that Mr. Dittman set out a potential modification or a potential amendment to main modification 25, which relates to the strategic gap, which would be, in simplistic terms, bringing that more closely aligned to the Eastleigh tests, or what Mr. Smith was setting out as the multiple dimensions of a sense of separation, talking about integrity, distinctive character, but there was a thorn there in terms of physical and visual separation that we discussed. But in any event, what Mr. Dittman kindly agreed to do was to work on that and on the reason justification behind LP6 to make that as clear as possible. And I suggested that in doing so, he should engage with Mr. Smith if there are examples of similar policies elsewhere. Did that all make it through? Was your connection okay during that, Mr. Hodgetts?
Yes, thank you, and I think that's a useful summary. So now I was just about to offer up our we're willing to engage in that process, as you pointed Mr. Dittman to do, if he as you suggested.
Okay, thank you, Mr. Dittman. Was that a fair summary from your perspective?
Yes, sir. And if Mr. Hodgetts has any similar examples, as we referred to with Mr. Smith, I'll more than happy to look at those and help me in the revisions we're going to be looking at. Thank you, sir.
Okay, thank you very much. That was, I thought, an exceptionally helpful discussion, very useful for me. Sorry if I asked some challenging questions, but very useful to get to the bottom of things. Thank you. Now that is on my list of notes. If I now direct us to paragraph 47 of INSP 5B, the person I had down who raised this was Councillor Thompson, who I don't believe is with us. which is entirely fair enough, as he may have simply made those points in his additional local plan representation. The issue, which is one we talked about during the previous Greenbelt session, is around the 30%. Sorry, I should take a step back. In terms of how Greenbelt policy operates, certain forms of development are not inappropriate development in the Greenbelt, whether that's under the previous National Planning Policy Framework 2012 or the current one. One of those is where there are additions that would not be disproportionate to a particular building. 30% was in the plan as submitted. 30% of the volume, I believe, was set out to be a threshold for where that may be encountered. I suggested that needed to be only indicative, and that is where we have arrived at currently in terms of MM21, MM22, that I don't particularly see a problem with the council using as an indicative guide whether a building would be increased by 30% or more, to inform a decision as to whether that may or may not constitute a disproportionate addition within the terms of Greenbelt policy. That's quite a canter through. I believe, and I'm just saying this to explain that I have had regard to it, I believe Councillor Thompson's point was that 30% reference point should be made harder, should be made clearer, so that the policy was effective and provided a clear basis for decision taking. I believe that was his point. Mr. Dittman or Mrs. Barrett, would you like to comment on that at all?
Oh, yeah.
Hi, so yes, the current situation is we would prefer to stick with the current main modifications. I've forgotten the number. It is 21.
21, yeah.
And as said, there is an element of flexibility in there. It is as a guide. We are aware of the concerns, particularly in the Greenbelt, that the changes to the General Development Order have enabled significant extensions that would go way beyond that in certain circumstances. However, it does often impact where we have developments that are more visually obvious, and that is basically the frontages and the immediate sides. Yes, we understand, and it was said, and I think this was said previously in the previous hearings, that if it's a general permitted development in the rear, less of a visual issue, then we will accommodate that. But where we do get control, and that's the critical bit, where we do get control, where control is an element of a decision making, then we would seek to go towards 30% as a guide. And this has another particular issue, because one of the difficulties we do have, of course, and we've mentioned this previously in the housing sections, is affordability and the potential loss of the market, for want of a better word, of the more affordable housings, particularly if you apply general permitted development order potential, and then also apply greater than, say, a 30%. So there are slightly more wider than straightforward environmental concerns here. There is also other potential issues. So I just wanted to remind you on that.
No, that's very clear, and I particularly like the phrase "wider than straightforward." I'll be using that one extensively. But no, that's a good explanation. I would tentatively and indicatively agree that, as you say, there are different sensitivities. The concept of disproportionate additions encompasses more than just a kind of a mathematical calculation, so I understand your perspective in that respect. Okay, I think I'm just pausing briefly, sorry, to look through what we have got. There seems to be a logical if we cover paragraph 48 of INSP 5B, and then we have a break, and that takes us about halfway through this afternoon's session. So turning to that paragraph now, and this is a point made by the Woodland Trust, I believe, which makes sense. With reference to the protection of ancient trees, for consistency, should all references refer to the latest Woodland Trust advice? So a bit of a cryptic point, but as I understand it, the Woodland Trust highlighted, and I struggle to remember, maybe it was even Mr. Bassett that raised the, or Mr. Owen, in a previous session raised the fact that there was recent guidance out that dealt with the protection of ancient woodland that specified a minimum buffer zone of 15 metres around it. That is what the Woodland Trust refer to. However, there are a number of other calculations in that respect. So the 15 metres, I believe, is a minimum. And I think, if I'm right, that is what the Woodlands Trust representation went to, and was suggesting that MM54 in particular should make reference to that minimum. I'm just going to MM54 at the moment. I'm sorry, I've given you the wrong reference. MM53.
53, so yes.
Yeah, thank you. My reading of that is that it is consistent with the Woodland Trust guidance. I'm not sure if they're then therefore referring to other references. Mrs. Barrack, yeah, can you help me?
Yeah. If I could help, sir, that the wording that he's put into his representation in ALP 44 is slightly broader than just the 15-metre buffer. It says a buffer zone around an ancient or veteran tree should be at least 15 times larger than the diameter of the tree. The buffer zone should be 5 metres from the edge of the tree's canopy if that area is larger than 15 times the tree's diameter, which is as clear as mud, really. So, and although it seems to be very detailed in terms of what we're saying there, so it seems to be 15 times larger than the diameter rather than a 15-metre buffer. So there seems to be a difference in the wording there. Because also then that affects H7, because the ancient woodland there at the Hollies, we do refer to a 50-metre buffer, which is what we were advised by Warwickshire Wildlife would be the indicative buffer around the ancient woodland. So
what I would suggest, thank you, that's very helpful, and yes, I have read through the Woodland Trust guidance, and it has multiple angles to it, if I can say that, in terms of what is the minimum kind of separation. But what I would suggest, indicative, is that MM53 doesn't change aside from a reference to a minimum buffer zone of 15 metres and in line with the Woodland Trust guidance. Just simply to make clear that there may be circumstances. I mean, generally a 15-metre buffer will probably be appropriate, but I think there may be other circumstances where there are particularly large trees or what have you that that a larger separation may be justified. So I think simply a tweak in that respect would probably resolve that issue. I'm not sure it's a matter of soundness, but nevertheless, I thought I would mention it as it's cropped up. So. I will leave that to you, if I may. So as you mentioned, Mrs. Barrett, H7. Now I have a couple of people down against this who may want to speak. 2 seconds. Let me just consult my list. And as you mentioned, there may be multiple issues there, not simply the fact that there is the Hollies, but there may be other landscape and visual issues, as we discussed when we were talking through that site specifically last year. Let me just see who I have down for this. 2 seconds. I have potentially Mr. Austin Fell, who may want to speak to this, I believe. No, I'm terribly sorry. I've got you in the wrong category. I may have Mr. Sitch.
Afternoon, sir.
Afternoon. Is there anything you wanted to raise on that? And I know this was particularly around, correct me if I'm wrong, the setting of Dorden Hall.
Okay.
No,
it's a separate point. I think it was
a separate point, right?
Yes,
okay.
Right.
Sorry.
So,
Yeah.
Can I just check, sir? Can you see my hand raised?
I can. Yeah.
Yes. Okay.
Yeah. Thank you.
Yeah, thank you. It's Mark Stitch from Barton Warmore on behalf of the Church Commissioners for England in respect of the land at Bosworth and Dorden, draft allocation H7. It was a point of consistency. So and Ms. Barrett's right. We did discuss it at the first hearings, and at that time we had the guidance that was, I think, supported by Natural England, talking about a 50-metre buffer, which was then subsequently withdrawn from their guidance. And the guidance we've got, as far as I'm aware, is a joint guidance from the Forestry Commission and Natural England, which is dated 5th November 2018, which deals with ancient woodland, ancient trees, veteran trees, protecting them from development. And that refers to a 15-metre buffer. And that's on the gov.uk website. So, and that's where I thought we were going to with your question 48. What I'm unclear on is the relationship or status, shall we say, of the Woodland Trust advice versus what is on the government website by the Forestry Commission and Natural England, which refers to the 15 metres. So I think the 15 metres is right, as referred to in MM53. If it is right, I'm not clear why then at H7, which is covered at MM84, refers to 50 metres. Clearly, it's a minimum of 15 metres, and so we wanted to raise it as to what is the relationship of that guidance to the Woodland Trust advice, but also if MM53 is acceptable, why is the same not acceptable in respect of H7? Please.
Yeah, no, I see that, and I've just in the background. Sorry if my screen was wiggling. I've looked up the what's on the gov.uk website in terms of guidance. For ancient woodlands, it says you should have a buffer zone of at least 15 metres to avoid root damage, where assessment shows other impacts are likely to extend beyond this distance. You're likely to need a buffer zone, etc., etc., etc. So I see your point about the sort of the distinction between those documents. I have to say I don't know off the top of my head their relative status and the intricacies, but I will have a look into that point. The second point was about the 50 metre buffer zone, as has come about in H7, which yes, there is ancient woodland involved, but as I put in INSP 5B, I remember a discussion about the sort of multiple factors in that location. I know there is a separate point, as you mentioned, Mr. Sitch, in terms of the setting of Dorden Hall that we can talk about. But
yes.
That it may be that 50 metres has been has emerged in light of previous guidance, or it has been incorporated into the assessment of that site previously. Can I get the any comments from the council on that point, please? I'll take away the point on 15-metre buffer zones in guidance, but if I can get any views on the 50-metre zone in terms of H17. Gosh, that was complicated.
In terms of H7, sir, it was just in relation to the Hollies itself, and making sure that the Hollies retains its a uniqueness in terms of its ancient woodland status. So that was the reason why we were advised by Warwickshire Wildlife originally that it should be the 50 metres. But as you'll see in the wording, we do say a 50-metre landscape stroke open buffer should be retained around the woodland unless demonstrated otherwise to the satisfaction of the council, forming a transitional area to ensure suitable protection to the ancient woodland from nearby development. So I suppose in the one hand, there are specific reasons why we did that around the Hollies, because the concern of the Warwickshire Wildlife Trust that they didn't want that the ancient woodland to be in isolation. They wanted to make sure it was connected. But if that's part of a wider discussion there in terms of the master planning of the site and making sure that there's ecological routes and things like that, then that can be something there. But I mean, our preference is that is being talked about with the local community and everything else. So we'd prefer to keep it to the 50 metres so that they're at least clear as to what is going on there. But I can understand that the guidance has now changed, and that if we do need to reflect that, or at least if there was a way that we can say that in a less precise 50-metre buffer, but because we've said that unless demonstrated otherwise to the satisfactory of the council, that there could be ways that it could be 50 in some parts and 20 in another, or whatever. So
can I ask sorry, one question? So there's this reference to the previous guidance that looked at 50 metres, and there is the Hollies within that site, which is a ancient woodland. Is it any other designations? Is it a local wildlife site?
Yes, if you see on the figure 1, sir, on in the local plan, you'll see that the buffer zone only goes around the ancient woodland part, and the other part of the woodland is actually a local wildlife site. But the buffer doesn't go around the local wildlife site. It's the ancient woodland site that the buffer is actually shown around. But of course, some part of that local wildlife site will be in the ancient woodlands buffer as well, because the two can join.
Okay, so I'm just going there at the moment. So sorry, you said figure 1.
Yes, sir. It's figure 1 on page 92 on the version that I've got.
Yeah, I see. Yeah, you're quite right. I was looking at the other plan. So,
so the dotted area, you've got the darker green in the middle.
Yeah.
And although it's all called the Hollies, only a certain section of it is actually ancient woodland, and the other part is local wildlife site. So it's the ancient woodland part that has got the 50-metre buffer around it.
Okay, and we've got Who Hill and the monument to the northeast, and correct me if I'm wrong, Dorden Hall to the east.
Yes, so you'll see if I can perhaps do this, and it's there. It's Dorden Hall. If that makes
A little
sense.
bit closer. Yeah.
Yeah.
I saw that briefly. That makes sense. And so at present, the ancient woodland is the dark green element, and the buffer around that is 50 meters that's been shown on the map.
Yes, sir.
So that's interesting, and that aids my understanding of where you were saying that there's potentially some flexibility in that distance, given that in part that will overlap a local nature reserve, in part that will affect land that is not otherwise designated. So I can see now a bit more clearly Mr. Sitch's point in terms of the sort of justification for that. But Mr. Sitch, the fact that at present H17 says unless demonstrated otherwise, does that give you any comfort? And if not, how, in your view, should that element be phrased?
Thank you, sir. Well, I think it goes back to the consistency point with the modification at MM53, and it relates to the ancient woodland, obviously. So Ms. Barrett's kindly confirmed that. So it's either I don't think unless demonstrated otherwise, the satisfaction of the council gives us much room to manoeuvre. To be fair, and it seems, as I say, it's inconsistent if other sites can have a 15-metre buffer or a minimum of 15-metre buffer. So maybe the solution is that it refers to a minimum 15-metre buffer should be retained around the woodland or the ancient woodland. And it says forming a traditional area to ensure suitable protection to the ancient woodland from nearby development. And obviously through the development management process, we will agree that buffer and the treatment around that, which obviously, particularly in the case of the Hollies, as you rightly say, we've got the local wildlife side as well. So there's additional protection, if you like, for the eastern side of that ancient woodland because of the local wildlife site.
So I was just looking at the other provisions of that. Sorry, no, I see your point, and in terms of, as clarified by Mrs. Barrett, that and sorry, I'm looking to the side. I've just got the plan here. As Mrs. Barrett has clarified, the justification for the 50-metre buffer zone around the ancient woodland seems to stem from guidance, which has now been superseded. So insofar as that 50-metre buffer zone is linked to that guidance, I think for consistency with MM35, that does indeed need to reflect a 15-metre buffer, as is the current guidance, in terms of its justification. However, I think there are other reasons, as we talked about, that potentially a buffer there is necessary in terms of the local wildlife site, potentially heritage assets, and also I see that in the elements of H7 there is discussion about a delivery strategy and community and key stakeholder consultation or engagement. Yes. So there may be very well-founded reasons there why a greater buffer than 15 metres is necessary in certain cases, but what I've heard is there's quite a nuanced discussion to be had about that. So I think if I could ask the council to reflect on that and provide some flexibility there, I think that would, that would be right.
Thank you, sir.
Is that okay? I'll put that on my list of actions.
Thank you.
Thank you. Now, someone's hand went up and then...
Sorry, sir, it was Mr. Dittman.
Yeah.
It was just to give a little bit of clarification as part of the discussions around the 50 metres that came in, and obviously we have this has been an issue to do with the master planning primarily, as well as the neighbourhood plan that goes back probably to the 2000 and I've forgotten what date it is now, probably 2009 site allocations plan. So it shows you how far we're going back. The location of the Hollies would at effectively a junction of two footpaths along a significant footpath, the Coffin Way, as they call it, between Polesworth and Dordon. They all contributed to that element of the buffer. And I think particularly from the amenity and open space opportunities, it was seen as a particular opportunity. And that opportunity obviously built on the Natural England guidance at the time, which obviously we referred to and we were advised was 50 metres. So it was looked at as not just a simple buffer for ancient woodland and veteran trees. It is operating as a much wider, multifunctional potential buffer, particularly for cycle routes, pedestrian links, wildlife corridors and similar. So there was that element of opportunity, and from the terms of the overall site development, that could be used by Mr. Sitch and the Church Commissioners, as we have mentioned in the past, as part of their open space provision. So there's an element of that multifunctionality that, although it might be seen as being overly oppressive or whatever, or extensive in terms of distance, if it is actually operating as a multifunctional land use, then it reduces the need to release other land that is more developable for development. And this is a particular issue that the opportunity was taken at that time as well, is because there was still quite significant concern, even around the 15-metre distance from the various wildlife trusts and the Natural England. Because we are looking at a significant size development and a potential situation where a local wildlife site and an ancient woodland might be at risk from being isolated, there was that need to maximise the potential of other uses around it to retain a protected distance rather than simply an ecological distance. Because if you have particularly private homes linking up to the back of a local wildlife site or an ancient woodland, there is significant concern, obviously, from, without going into too much detail, pets and children and the implications. Again, it's going to be part of the overall master planning and there will be management involved. But if we can achieve a slightly larger buffer that's a multifunctional opportunity, that was the approach we were going towards. Thank you, sir. That was really all.
No, thank you. And, you know, I mean, I have, again, just explaining that I have walked around the Hollies and that site and I'm relatively familiar with it and do see your point. And I think that's reflected in INSP 5B, that in terms of H7, there may be multiple factors at play, and we've discussed some of them. I think the point I was making, that in terms of the specific justification for a buffer in terms of ancient woodland, there's no getting round really that consistency has to be had to with the latest government guidance in that respect, which, as we've talked about in other regards, is a minimum of 15 metres. So the tweak there could be something along the lines of a minimum of 15 metres, insofar as that is justified with reference to ancient woodland, albeit that subject to master planning, community engagement. There may be justification in other respects, and the other respects, picking up on the point that you've mentioned, Mr. Dittman, include the nature reserve, footpath, amenity, open space, and potentially heritage. But I can understand that in order, I can understand Mr. Sitch's point that in order to find a plan sound or an allocation sound, it has to be justified by appropriate evidence. And with the specific issue of ancient woodland, I think we are now in a position where there is new guidance. So I hope that that explanation helps. And if I may ask you to consider that, and I've put that on my list of actions as a potential main modification.
Thank you, sir. Yes, I do take that point and the consistency issue from Mr. Sitch, and I do take that on board as well. Thanks, sir.
Okay. Thank you. Now, I would like to take a break until 10. Oh, Mrs. Barrett, are you going to tell me that I can't take a break?
No, it was just in relation to the 50-metre buffer, sir, because I believe that there's two other references within the plan to 50-metre buffers. So if we're going to change them in one location on one site allocation, I'm assuming that they need to be changed in the other two. The one that I can find straight off is it doesn't have I think it's MM96 for H20. Also refers to the provision of a 50-metre buffer will be retained. So that again has to be changed. And also I believe it's in H2, but I was struggling just to find it there.
Okay, well, yes, I mean, in principle, you're right. And I think if you kind of go through that process of looking at sort of H7 first, that the point is that it should reflect, the latest Woodland Trust guidance, which says a minimum of 15 metres. I think that incorporates the Woodland Trust's point about there are potentially other dimensions to consider, which is reflected on the .gov.uk website, and then not in the case of H17, not to the preclusion of the master planning process and all the other considerations. That may be the same for other references as well. So, I wouldn't want to say, yes, absolutely, kind of just put that 15-metre reference. Yeah. If there are other reasons, landscape reasons, wider reasons, keep those in. But I think probably dealing with H7 will then enable you to look at the consistency. But that's an excellent point. Okay. But the plan has to be consistent unless there's sort of justified differences. And that is a point that we'll come on to in relation to heritage as well. But thank you. Okay, that's very helpful. So let's break and come back at. Let's go for 5 to 4. Give us a bit of time, where we will be discussing 3 questions really around flooding, emergency services, green space, minerals, etc. The remaining, and I'm sure there is heritage somewhere in there, the remaining points that are under environmental considerations and heritage. So I'll adjourn now. We'll come back at 5 to 4. Don't hang up, of course, unless you want to leave. But we'll keep the recording rolling, but just without our faces showing, and then we will come back at 5 to 4. So thank you. We're adjourned.
Just starting, sir.
Thank you. Okay, let's let's reconvene. Let's make a start. And as you can see, it's the time of day when the white balance on my computer goes very odd. So sorry if I change colour during this. But we're back on INSP 5B, which is the agenda, the matters, issues, and questions on paragraph 49. We will, towards the end of the session, touch on a couple of points around consistency of references to heritage assets and some administrative matters. I think heritage, I mentioned earlier, is also there in paragraph 64, which we're going to consider tomorrow. So that will just be sort of flagging up some issues there. But on paragraph 49 of INSP 5B, I have, well, Mr. Austin Fell may wish to comment on this. I have seen representations in relation to the additional local plan consultation, but is the approach taken to the selection of sites or allocations, I should say, compliant with the sequential test in the NPPF 2012 in respect of vulnerability to flooding? Now, this is something that I have asked previously. I have the position of the Environment Agency based on the latest evidence that the council has provided, clarifying the approach that they have taken. But as I have it, the point raised by Taylor Wimpey and Mr. Austin Fell may wish to speak to this, is about the methodological robustness in that respect. Mr. Austin Fell, did you want to comment on that?
Yes, sir. I'll comment on this briefly, and I think you know, you've read my representations, which
Sure.
I'm very grateful for you to do, directing your attention there to paragraphs 4.11 and 4.77, where the bulk of the response is made clear. So in short, we've got some concerns with the approach taken in how the council have approached the sequential test as set out in paragraph 100 of the 2012 MPPF. In summary, the concerns relate to the sites that the council have selected and whether or not those sites have been selected without first looking at those which offer a lesser sensitivity to flood risk, not just now, but in the future, with consideration to changing factors such as climate change. So in particular, I take you to document NWBC 24B, which is concerned with the sequential test for Atherstone. As part of that document, the council outlines what they consider to be their concerns for the town itself, and the cumulative planning impacts there concerning transport, heritage and other matters of the natural environment, which forces them to look towards the north and east of the town. And on Appendix 2 of that document, you'll note that that direction of the town is subject to flooding. Now, Appendix 1, whereby they look at the factors relevant to the sequential test, you'll note that they've made an approximation for each of the sites in Atherstone and how much of those sites fall within the flood zones 1, 2 and 3. I don't wish to go through those chapter and verse, you'll be grateful to hear, but just taking some in turn, the Atherstone football ground, site H3, is noted in Appendix A as falling 32.7% within flood zones 2 and 3. Site H1, 47.5% within flood zones 2 and 3. What I should note at this juncture as well, sir, is whether or not the council has robustly accounted for the implications of climate change as part of the sequential test, as explicit in bullet point 5 of paragraph 100. My concern, sir, here is whether or not the report has been robustly taken, but I would welcome a response from the council as to why other locations outside of the flood zone haven't first been explored before venturing into these locations with these sites. Thank you, sir.
Thank you, and I think those points are very clearly explained, and I will put them to the council. But I would also just welcome from the council an explanation of, and sorry for labouring the point as we have been through this, but just a brief history to the site selection process, which I know originally was initiated as part of a what was proposed to be a separate site allocations plan. But if you could just briefly talk me through that history, and indeed, I think it was NWBC 24. There are various appendices to it, but I think Annex D, NWBC4 Annex D, were points responding to the sequential test. If I could ask for that brief history of the kind of site selection process to be set out. Any comments on NWBC 24 and Mr. Ostenfeld's point about whether indeed other sites have been considered, and the sort of preferential approach in paragraph 101 of the NPPF 2012 taken in relation to site selection? Thank you.
Thank you, sir. Yes, the approach to sites in Atherstone does have quite a considerable history, going back to the earlier local plan and subsequent site allocations that was dropped prior to coming forward with the current plan. Obviously, the availability of sites through the SLAR was one of the foremost routes we did take and pick up sites for consideration. We did apply a number of criteria to that analysis as well. So we wanted sites that adjoined as much as possible the immediate development boundary, or were within the development boundary, obviously. We were, to some extent, and this is part of the difficulty we've always had with the flooding issues, we were, to a certain extent, hamstrung by what individual landowners or developers actually physically submit to us. So with particular reference to the comment Mr. Ostenfeld has mentioned on regards the two north western sites, and it may be our fault in doing it this way, we reflected what had been submitted, more or less. So for H1 and H2, in the early stages of the site allocation plan, H2 wasn't directly being proposed in that extent because we didn't have that scale of development. It was primarily H1, and we reflected the boundary of the ownership of the site that the particular landowner had submitted. Our intention at that time, obviously, was to address any of the flooding issues by excluding them from the flood zones 2 or 3. But as you will be aware, particularly with regards to H1, because that situation is still ongoing, we do have 2 planning consents applying to it, whereby the flooding issues were addressed. Now, they were submitted to the authority outside of the local plan process, and we still have a principle to approve those sites, subject to the ongoing negotiations with the landowner. So that, to some extent, reflects the circumstances where you have an existing ongoing approach and a planning consent imminent from a particular site. But we did look at all the sites referred to in, I think it's NWBC 24C. If you go back to the earlier SLARs starting around about 2009-10 and subsequent ones 2013 and 2016, not all the sites appear every time, because sometimes they fell off the SLAR by virtue of the fact that they weren't submitted at that time for whatever reason. However, we were still aware of them, and we have still been aware of them all the way through this process. Now, I understand the issue of the sequential test, and we believe we have approached it correctly. Obviously, we are focusing on Atherstone, and in terms of the needs of Atherstone, in terms of the assessment. And we were very aware, particularly because it's an issue that the council has always been aware of the difficulties, not just with the flooding, but with the other implications of availability through heritage, access grounds, and local wildlife sites. So it's the heritage, the ecology, and the access issues as well. and hence that lends itself to a focus primarily towards the northwestern corner, inevitably. Elements of the far west have issues of access onto the A5 or the impact on the heritage issues of Merivale Hall and the Merivale Abbey locations, as well as the historic park itself and the various local wildlife designations and ancient woodland designations that that land also has. I understand where Mr. Holstenfeld is coming from, because I'm assuming he's referring to the sites to the southeast on the corridor out of the settlements along the Nuneaton Road, Manchester Road route. There were concerns that the site submitted at that time had not a direct relationship immediately to the development boundary, and did not have, it did have issues of significant concern regarding the ancient monuments at Manchester. And it was that element that primarily was focusing the discount of those sites from the availability. The flooding issue and the climate change issue, we always felt could be accommodated within the sites that we did move into. So it isn't an automatic discount simply because parts of those sites are affected by flooding. And this is what we always were approaching with the Environment Agency and others to do. And it was a little bit frustrating to some extent that maybe we weren't clear enough in making this clear. We were looking at the opportunities those sites can deliver in capacity, but also, given their locations, the implications of the flood zones, what that could do in terms of contribution, and people could disagree with us in this approach, to open space, amenity, wildlife corridors, transport links, and such like. So that was the approach we took. And it's because of, to some extent, the literal wording of the guidance that if a site has an element of flooding, irrespective of its 0.1% or 99%, there seems to be the assumption that on that basis, those sites can or should be immediately dropped. We didn't take that approach. We looked at what we could accommodate within those sites, given that they had significant other benefits in terms of scale and location and opportunities. And that is the approach we took. The climate change element, because obviously we were pre the 2016 changes at the time, we took on the basis that further FRAs would still be required, and they would help enable the climate change implication to be undertaken. We were aware of, obviously, the fact that the planning applications that had been submitted, particularly on the H1 site, which is the Durno's Nursery, and the Merivale Holly Lane sites, had gone through quite a significant series of flood risk assessments, as well as the EN6, I think it is, 5 on Ransom Road, which is the employment site, and that was sufficient to address the issues. And I understand the climate issues from the Environment Agency's point of view. They are applying the latest guidance, not the 2012 and the earlier guidance. This is the difficulty, obviously, with the transitional plan. So from our point of view, we'd complied with the sequential test requirements. We complied with the requirements to address the climate change, and where there were shortfalls because of emerging and improving requirements, we would address that through additional FRAs at the time of the application. And again, this is one of the issues that was raised by the Environment Agency. They had concerns that in doing that, we weren't able to robustly assess the capacity of the site, as we were suggesting. And that element we tried to address through, I've forgotten the exact document. It is possibly MWBC 24B, D and C, but it's the issue that refers to the comments that we've already made about flexibility inbuilt into these sites, whereby the 60-40 split and the 30 dwellings to the hectare reference gives us the capacity to be fairly reassured that we can accommodate any of the climate change implications in the future, notwithstanding we're still going to have to go through a more detailed FRA. But that also led us on to then make it more clear in the proposal plan mapping that we would be make it quite categorically and specific that those elements of those sites that currently fall within the flood zone, we would exclude. Not exclude from the site, because I think that would be a loss to those sites' developments, because they provide an asset, an additional open space, recreational, ecological asset that I still believe we should keep within the site. The Environment Agency don't have that element of planning at their remit. All they want to know is the developable area is outside of the flood zones and any future impact is going to be taken into account. And I'm hopeful that we have reassured them of that through the proposals map route, albeit I am aware they still have the issue about how to reflect that in mapping terms. And I do have a point to raise a little bit later on that if the inspector so wishes.
Okay, thank you. Yes, yeah, no, that's a helpful explanation. And as I've noted, the history goes just to strategic housing land availability appraisals. I then see the sustainability appraisal that was done for the site allocations plan previously, which is on the examination website, which does look at alternative options for sites. Skipping forward a bit, I see that in your heritage note that I asked you to clarify exactly how different sites have been treated, there are references to how the names of different sites have been considered or assessed since the site allocation and SHLA to the present day. So that's a helpful sort of codicil there. And then finally, I see the latest representation from the Environment Agency, which goes under AEC3, which, and this is a point we'll come on to, I think it's under paragraphs 60 and 62 of my document, but the Environment Agency does not recommend that certain maps showing indicative flooding areas more vulnerable to flooding are included, given some issues with the data there. But can I just check one thing in all this, though? The latest maps, which are AD 54, are those based on the current EA mapping?
Yes, sir, they are. The only difference that we referred to related to H1, and this relates to the planning consent and the flood risk assessments that were undertaken with the Environment Agency's own engineers. That resulted in the area A and B that you see on that current map. That is the only area that there may be an anomaly between what you see on the gov.uk website, but that has been agreed with the Environment Agency. Now, I am aware that there is an issue from the Environment Agency's point of view in terms of which department you deal with. If it's a planning application, then that boundary is agreed. If you're looking at strategic, then perhaps the earlier versions should be used. The difficulty we have is that we do have planning consent expected to be finally signed through the Section 106 on both those sites, for which an agreement has been made with the Environment Agency for the area for delivery. And that is what we currently reflect. If things change, we will have to reassess that. But at the moment, that is particularly with that regard that site, and I know that was an issue. Everything else is effectively as is now, and with the application of an FRA level 3 and 4, After that, when we get the applications, we feel that the flexibility and the ability to address the climate change concerns that the Environment Agency have is built in to that site proposal. Thank you, sir.
Thank you very much. And can I just check an FRA, a flood risk assessment level 3? That is a term, I have to admit, and this may be my failing, I'm not particularly familiar with. I would generally call it a site-specific flood risk assessment, but I may be wrong. There may be a document out there that sets out what levels 1 to 4 are. It
may be myself, sir, because I've always reflected them. The more strategic assessment was always an FRA level 1 and 2, and the more site-specific was FRA level 3 or 4, depending on the level you were going to. So that may simply be my failing in terms of the personal distinction between the two. But yes, it is a site-specific, but a much more up-to-date, detailed site-specific that addresses climate change implications at the time of the application. And I think that's the relevant issue, that's now built in to the proposal. The difficulty, of course, you could have a circumstance where part of the site comes forward as a result of a phasing development that is wholly within flood zone 2, flood zone 1, outside of flood zone 2 and 3. And the question has been raised with us in the past, would that then still require it? Now, the likelihood is we would still expect one because of the implications in the EA guidance, as you're aware of, on the flood risk, that if it's part of a wider site, you still need to address those long-term climate change issues and the implications such sites would have. So that's why it's now built into the proposal, the site policy, and it is, as the Environment Agency requested us to do, a requirement of development on that site, irrespective of where it is. Thank you, sir. Okay, thank you very much. And I've got the Environment Agency's latest representation, even though they're not represented here, so I can see that. Thank you. Unless anyone wants to say anything else, I think that's all I need to ask in relation to that particular aspect of flooding and the sequential test under paragraph 49. Thank you for that. Now, I'm just looking to see if anyone's hands up, and I'm terribly sorry that my my white balance is going. It's very distracting for me as well. Mr. Dittman, sorry. Sorry, sir. Just coming back to your earlier point regarding the reference to the EA's concern over the mapping. This goes back to an earlier point was raised this morning relating, sorry, not this morning, this afternoon, relating to H7 and Mr. Sitch's issue regarding the woodland at Holly's Lane, sorry, at the Holly's Wood. Holly's, yeah. Having had a quick discussion with Dorothy, my manager, if that still remains an issue, because we would prefer it to be part of the proposals map, and we know the objection and the concern is still there that EA are uncomfortable with that issue. There is another alternative. We could use the approach taken for H7 and simply have a figure similar to figure 1 that you looked at earlier in the plan. That is an approach. As I say, we would prefer not to, but if that still felt to be an issue that concerns the EA, and then what happens to the mapping is it becomes more indicative or illustrative, and that is, I think, the critical issue that the EA were concerned about. They think the mapping, as we show it, is so definitive, it doesn't give the flexibility. Perhaps bringing it in as a figure and identifying it, these boundaries are illustrative, reflecting the current flood risk at that time. That may give them a little bit more reassurance. Sorry to just put that one on you, but it is something that just has come up specifically as a result of the discussion we've had. No, that's fine, and I mean it is something that's addressed in their response, and I think probably the way I'm sort of headed is that given that the individual allocations will inevitably be the subject of a
level 3 or a site-specific flood risk assessment, which may arrive at different, very site-specific contour modelling, etc., then it probably is not advantageous to include those maps, but just that they sit there as evidence underpinning them, really, rather than kind of form part of the plan, which would potentially give them excessive weight, if you see what I mean.
Yes, sir.
Yeah. Okay. Or undue weight. So let's go on to hopefully these will be relatively swift questions, and I can see some people have clearly made the points that they wanted to and are disappearing. But paragraph 50 of INSP 5B, there's reference from Natural England that they are of the view that reference should be made in policy LP16 towards an emerging nature recovery network. I'm not sure whether or not that is a matter of soundness, but it is something that Natural England have clearly raised as potentially relevant to LP16. What's the council's view on that, whether that's necessary?
In terms of the policy itself, we're in your hands, sir, but the alternative is to put it into the reason justification that is being developed both at a national level and at a local level, because I think there's the nature recovery networks and then there's the local nature recovery strategies as well. So so whether that could be more akin to an update in the RJ rather than to the policy itself, but
I think
yes.
I think at risk, I will leave that over to you to consider. I mean, I think that wasn't necessarily a fundamental point in terms of the soundness of that policy. That was a as you have said, that was an indication of what might be a helpful reference rather than a fundamental problem as they saw it. So I will leave that up to you. I mean, obviously, I'm looking at potential main modifications. It's within your gift to look at additional modifications. I believe we've talked some through previously in terms of certainly waterways and heritage and whether they may be considered as non-designated heritage assets, even if they're not formally designated. So I will leave that. I will leave that sort of in that territory for you to consider. Thank you. Now, a similar one, Warwickshire County Council have suggested, sorry, this is paragraph 51 of INSP 5B, have suggested, and this is quite specific even for me, that policy LP 35, which will now be titled Water and Flood Risk Management, should reference surface water discharge being reduced as far as practical to greenfield Q-bar. Now, that may mean something to you. I'm afraid that is slightly beyond my knowledge. As I understand it from a little bit of research, that's the standard in terms of runoff. I'm not convinced that's a matter of soundness. That's probably a matter of applying the relevant standard. As I understand it, that is set out somewhere in Warwickshire County Council's standards for drainage. So, if you feel it's necessary to make reference to that, please do so. I'm not convinced that's within the territory of soundness. But,
the only comment that I would make, sir, is that it was very specific to the amount of the greenfield Q-bar, and so what I was concerned about was about the that changing over time, and that makes the policy out of date. So I didn't know whether it should just be as it is, and again we could refer to the latest guidance into the RJ.
Yes, I think we're in a similar space, aren't we? As in the emerging nature recovery network. That if you want to make that linkage by way of an additional modification, that's fine. I'm not convinced it's of such significance, because that policy anyway refers to achieving or exceeding natural runoff levels. So that applies a specific standard. Whether that's relevant to soundness or just a practical piece of guidance, I'm not sure. Okay, I'll leave that over to you. Paragraph 52. For soundness, should reference be made in Plan Policy LP2, and that's one we've talked about, potentially some fairly comprehensive amendments to. Should references be made to emergency services infrastructure? And if I can summarise in one word, the representation of the police, their representation on this was yes. Any thoughts from the council on that?
In terms of LP2, no, sir, because that's to do with the settlement hierarchy itself. But within the MM14 on page 3 and going over into page 4, I'm just checking again because I thought we had the police. Because in terms of the IDP, we do include the emergency services, so they are already referred to there, and the supporting of the communities. But in order to get something built properly, then you would expect there to be some warrant on the police time and things like that, because there's a greater population. But it's not. Again, I'm in your hands with that one.
Yeah, I mean, I think given the MM14, and you're right, it doesn't refer to LP2. That's about services and facilities and infrastructure, isn't it? MM14. So that's probably my error in putting in the wrong policy at that point. But nevertheless, I think, as you say, given that emergency services infrastructure is referenced in the infrastructure delivery plan, and that new paragraph, which is not a policy, is it? It's just an explanation of the types of infrastructure that may be considered. I think that would be useful, yeah, to include emergency services. It may already be in there, but potentially not very clearly. But that would certainly make it consistent with the evidence in the infrastructure delivery plan and in terms of various aspects of the NPPF in terms of services and facilities. So yes, please, to that. I'll put a note of that. Okay. Thank you. So I'm not sure if we have anyone here from Osprey Parish Council, do we? Now, I know we've gone around local green spaces and I forget the document references, but I wasn't convinced during the previous session that some of the green spaces had demonstrably met the test in the NPPF 2012. The paragraph there doesn't immediately trip off my tongue, but I think maybe 83. But that demonstrably special in some way. Now, as I saw through the additional local plan consultation, Osprey Parish Council suggested that a number of other areas are which weren't previously identified are identified as local green spaces. Now, my question is, would those areas, if the council has considered those areas, would those areas meet the criteria of the NPPF in terms of what local green spaces do? And then secondly, would the plan be unsound in their absence? So, Mr. Dittman.
Thank you, sir. We did look at these sites. Obviously, they've been primarily generated through the Austri neighbourhood plan. The difficulty we have, we don't believe that they all do comply with the criteria you mentioned in terms of the open space needs, but also the majority of them, and I've just had a check with my neighbourhood plan colleague to confirm that, the majority of the sites they refer to actually lie outside the development boundary. And we have, as far as the plan process goes, always taken an approach that we will try and avoid designating unnecessarily sites outside development areas. If the sites themselves aren't going to be potentially pressured or affected by development, they lie within greenbelt, open countryside, or have current uses, particularly if we're relating to open space and recreation. There is an element of protection already inbuilt, whether that be through the general policies, LP3, LP5, and the development control policies for loss of open space, or similar. We felt it's unnecessary to give them a further designation as open space. And we have been criticised in the past for having, for want of a better word, multiple constraints or multiple designations applying to sites. That is unnecessary, particularly, as I said, in open countryside and greenbelt, where the principle of constraint already applies. Hope that helps.
Okay, yeah, that does help. That's a very useful explanation. Now, if I may just briefly share my screen. So you mentioned the Austrian neighbourhood plan, which I think I'm right in saying is made and therefore part of the development plan. If I can just share my screen at this point, I'll make sure I get it right. This looks to be the relevant element of that, which shows some areas indicated there for protection. Do you by any chance know if effectively there's any, you mentioned there's overlap with potential other designations, i.e. greenbelt, but is there any overlap between what has been identified in the neighbourhood plan versus what is proposed by their representation here?
No, not that I'm aware of, sir.
Okay.
And also, just looking at those sites straight away, I can see the majority. Would it be possible just to put that up for a brief second again,
yeah,
sir?
2 seconds.
It may explain how being a development boundary anorak can seriously affect your thoughts.
There's only one inside.
But I'm fairly sure there's only one inside, and I'm just getting confirmation from my colleague that's the case.
Here we go. It's just coming. There we are.
Yes, sir. Bishopsfield, that lies outside the development boundary. That is an area particularly affected by the Grade 2 star listed church. Austria Playing Fields definitely lies outside. Old Cricket Ground, similarly, that lies outside. Land beyond Hollybank as well, I'm fairly sure, from what I recall, because that's next to the small council estates. That also lies outside the development boundary. I think there were some other smaller scale sites they may have referred to, but they would be within, and they would be, if not reflected by the local plan. As you say, the neighbourhood plan is part of the development plan, so there would be an element of protection through that approach.
Okay. So that, the second document I showed there was additional local plan consultation document 54, which was a representation from the council just highlighting the various sites that they had proposed. That's a very helpful clarification. Thank you very much, Mr. Dittman. I think that's all I need to hear on that point. So what I've heard from the council is that there are parallel designations that afford substantively similar protections in that respect. Now, then paragraph 54 Is the plan and proposed allocation H13 consistent with the approach in the NPPF 2012 to facilitating the sustainable use of minerals? Now, this was a point that I thought was relevant to some potential main modifications. Let me just get those in front of me, because obviously I just want to ensure that the linkages between this local plan and any minerals plan are accurate in terms of the NPPF 2012. Can you just remind me where the minerals plan is up to at this point in time?
The minerals.
The counties.
Sorry,
sorry,
yeah. The minerals plans went to virtual hearing about a month ago, I believe. Might have been October time. So that's awaiting. I'm not aware that the inspector's report been received yet, but I think it's imminent. And in terms of H13, that isn't, as far as I'm aware, affected by any minerals site. That's on the border with Birmingham. So
let me just see. I'm just going to quickly search through my notes and see why I've put that in there.
That's what I was trying to do. I was trying to find in the plan what references.
no, it's me, sir. I've got the wrong site. H13 is the one that is adjacent to the Tamworth Golf Course. I thought it was the Langley Sue site. So apologies for that. That was me causing a bit of issue there.
I was just looking through. You could have played it off. That would have been.
So that would be. I'm just looking at Mr. Dipman here. That would be in the Northern Warwickshire Coalfield.
Yes. It partly is.
It's partly within the Northern Warwickshire Coalfield area. I don't believe it all is, though. I think it's just the very northern area.
Just to clarify, sir, yes, Mrs. Barrett's correct on that one. The Northern Warwickshire Coalfield, I forgot the terminology, but it's a safeguarding area they indicate in the English local plan, cuts through the northeast and northern part of the site. Effectively, this site is just south of the former North Warwickshire Coalfield, or Tamworth Brickyard, where the canal yard is. So there is some past history, but only at the northern end of the site. The predominant implications for any minerals issues actually lay within the Tamworth area on their former golf course site, and that's now being developed.
Yes, yeah. Okay. Thank you. That's very helpful clarification there. So I've also so can I just bring your attention to, I'm sorry, I'm looking to the side. I'm just trying to look at a number of documents. So paragraph 2.19 of the plan, where development is proposed on land with mineral reserves, consideration must be given to the extraction of the mineral before development takes place in accordance with national guidance. In terms of the coal reserves from the Northern Warwickshire Coalfield, the council will not support surface mining operations where it will have a direct effect on local residents and an adverse environmental effect. I was just looking at the consistency, and this may simply be nothing to do with intention, but just wording. If I look at the NPPF 2012, 2 seconds.
Is it 147?
149. Yeah. No, you're in the right territory. So it's just a slightly different wording, I think. And all I wanted to do, I'm not necessarily saying that's a matter of soundness, but it's just something for the council to reflect on. Permission should not be given for the extraction of coal unless the proposal is environmentally acceptable or can be made so by planning conditions or obligations, or if not,
It isn't. Sorry, sir.
No. So I didn't know if effectively paragraph 2.19 was setting a different policy intention to that of the NPPF 2012, or whether that should simply be the sort of matters of minerals should simply be deferred to the county's plan. But over to you.
Thank you, sir. No, it's not intending to be a different approach to 2012. Again, we do have the issue, of course, of this plan being in a transitional position. And with reference to the latest minerals local plan, we did raise a number of objections, specific objections regarding the coalfield safeguarding area, former coalfield sites, and also the status of coal given the current national energy strategies and the move away from coal. Now, those objections have been accommodated and were subject to change and modifications in the minerals local plan. So it's we're in this strange position that actually what's happened has gone beyond 2.19 to some extent, and the lack of commitment or intention to enable coal, it's specific to coal, sir, not to other minerals, specific to the coal, to allow and accommodate coal extraction. And that's there's been increased environmental concerns and marketing concerns as well. In other words, in the absence of a market, again, that affects the need to do prior extraction. And it was all focused on that prior extraction. Sorry for going on a bit, because it does sort of reflect the 2012 issue that we were referring to, but be aware that if you do go to the current minerals plan, which is literally hot off the press, as we said, it's only been through inquiry in the last 2 months, there may be a mismatch between our plan as it stands based on the 2012 and the actual objection we referred to and the subsequent minerals local plan 2019.
Sure. I mean, that's a very helpful update, and effectively we're dealing with two moving things at the same time. Well, three if you include the new version of the NPPF. So no, I see that. I just wanted to clarify there was no intention of diverging from the NPPF 2012, and it would be just to just for the council to satisfy themselves really. If you search through the schedule of main modifications, potential main modifications, a few come up which reference the minerals plan, just to be sure that as things are progressing, that those are consistent with the approach in the NPPF 2012, or indeed with the emerging minerals plan. I think that would just be a useful exercise, so there aren't any things that raise eyebrows in time. But thank you for that clarification. Okay, I don't really feel that I need to particularly ask the question in paragraph 55, should allocations set out definitive or indicative capacities? We've talked about the assumptions that have been plugged into the capacity of sites. We talked about headroom. I believe this was indeed a previous question where I'm not entirely sure that we came out as an answer either way. I mean, if the council want to say anything, that's fine. I mean, as they're phrased at the moment, I think a lot of them, correct me if I'm wrong, are anyway phrased as a not as a specific number, but as an indication. Correct me if I'm wrong.
Yes, sir.
Yeah.
That's correct.
Okay, well, I think I don't need to press that anymore, provided that they're all as an indication, as a rough indication, and that's consistent with the assumptions and methodology that's been used to calculate site yields, etc. That seems to be flexible and appropriate. Okay. I did say we might touch on heritage, but I think I will leave that. I will just flag up that there's some point about consistency of references in a similar way to ancient woodland, but we can discuss that. That comes in more in terms of, because I know there's been extensive work with historic England in terms of the general approach to heritage, but that comes in more in terms of individual sites. And it's just to be clear on the consistency of that wording, or where that diverges, because there are particular assets that would be affected, that kind of is clear. But I think that's just a point of internal consistency, really.
I think in relation to that, sir, the Heritage and Conservation Officer has given me a response.
Okay.
And if you would like me to share that response, I can do, because it basically says that there are issues that are different on the various sites.
Okay.
So that's the reason why it's important to make sure that they do reflect those individual sites.
Excellent. That would be very useful. If I could ask that is, I'll just make a note of that. That's put on the website. If you're happy to do that, if that view is okay to be put up on the examination website, that'll be useful. Okay. Now, that brings me to the end of all the questions I wanted to ask at this stage. Tomorrow in the morning, we're looking at allocations, which will have some bearing on stepped trajectory, as we discussed in the first day. We're picking up some additional points in terms of flooding and heritage, sort of site by site. But I think that if you are able, Mrs. Barrett, to pop that document up, which explains the different justification for different phrasing of heritage issues, that would be useful. And then in the still in the morning, we're looking at the updated Gypsy and Traveller Accommodation Assessment, which is AD 40. Is it AD 40? And then in the afternoon session, we're going to re-look at a few issues, go through main modifications, and then talk about any other matters and some administration. But it seems like, from my perspective, we're broadly on time with that. If I just say, I hope everyone has found that useful, and if I just ask if there are any points anyone else on the call wants to make at this stage in terms of the substance of the discussion, that would be very useful to hear them now. Otherwise, I'll move on to a sort of administrative roundup of basically the points that I have, the actions or the potential main modifications or tweaks that I have listed in the course of the discussion. So is there anything anyone else wants to raise at this stage? Otherwise, I'll go on to that run through. Okay, and I'm very conscious yesterday I rambled through it at great speed, so do tell me to slow down if needs be. So in terms of the actions as I have them, there was a point of clarification about the approach to the calculation of the Coleshill Hall Hospital site, whether that is 16.38 hectares or otherwise, to input into, now, was that NWBC 45 or 50 A and B? Anyway, I don't need to find that reference now, but it was just that clarification. Secondly, to update on the examination library and website, which may have already happened, the development consent order for the strategic rail freight interchange off the M6 at junction 12. It was also to upload the report on logistics and coronavirus to the examination library. Again, I've seen emails on that may have already happened, so thank you very much for dealing with all that very efficiently. Next one I have, point 4, is to look at, in line with Mr. Dittman's comments, MM35, potential MM35, or the new policy LP6, and clarify in some form or other how it interacts with policies LP2, LP11, LP3, and LP5, and some tidying up. No, I've got that wrong.
I believe so. That's MM25.
That's 25.
Yeah.
That's 25. Yeah, you're quite right. You picked me up on that earlier, and I should have learned. I realised partway through saying that. So that's MM25. Thank you.
You're just checking that I'm awake, can't you, really?
Then point 5 I have is indeed MM35, new policy LP6, and how that'll be monitored. I think I said I would have a think. That's not one for the council. I would have a think, because we discussed about monitoring indicators. I would have a think if anything further is needed there. As in earlier sessions, there was some discussion about, I believe it's main modification 7 and review of the plan in the event that circumstances change. There was some discussion we had about whether or how that trigger should be triggered, whether it's on housing or economic land and what figures could be used. But I think I just asked the council to have a think about some specific monitoring in that respect, what would bring that into play, what would bring that review into play. Again, the council kindly undertook to upload potential changes to the plan as submitted that would address any flexibilities that have been introduced recently in terms of use classes, and how that has a bearing on various policies. Then I have, based on Mr. Dittman's comments, some consideration of the third criteria of the meaningful gap policy, and the issue around what factors would be considered in terms of separate identities, or the separation or the functions of that policy. We then talked about, this is point 9, ancient woodland guidance and 15 metres and the correct references where that is the justification for something to the Woodland Trust guidance. We talked about how in that context, and this is related to site allocation H7, how the 50-metre buffer is treated. Based on our earlier discussions in terms of master planning and the other factors that may be at play there, but still referencing the ancient woodland guidance. I will check whether level 3 flood risk assessment is a term I simply wasn't aware of, so that one's down to me. I said that reference to emergency infrastructure should be made via main modification 14. And if it were possible, if they are in a form that can be done, otherwise if they're not, we can simply talk it through. If the council are able to put on the examination website the latest comments from heritage officers as to why different allocations treat heritage matters differently, that would be very useful. Thank you. Is there anything anyone has that I've missed on that list, or any other points to make? Mr. Dittman.
Sorry, sir, just an administrative, that's a mouthful, issue. The reference
for the Heritage Officers document. Do you want it as an additional document or a NWBC document?
I don't know there's much between it, but I'd probably say NWBC 30 as it comes from the council.
That would be helpful.
Yeah, that sounds good. Okay, is there anything we need to think about for tomorrow? So for tomorrow morning, this is just a sort of a point for the council. I said I set out, I believe, some potential tweaks to the option 2 trajectory around the years when the Coventry and Warwickshire SHMA became available, became agreed. Are you able to talk us through that point and insofar as it affects the trajectory in relation? I just want to check if that's all okay for paragraph 56 tomorrow morning.
Yes, sir. I just need my colleagues just to check my maths and everything else. But okay. But I've done a table. I've done the revised options. How then that affects table 7. But also then how it affects the 5-year housing land supply. So there'll be 3 tabs on the Excel spreadsheet that will eventually come out, but I can go through it tomorrow and explain what those are. Yeah,
if we could just talk it through tomorrow, that would be excellent. That would be a good starting point. Yeah, and then we can come back to, although we've dealt with it in a fair bit of detail, the current sort of trajectories and assumptions and work out that step trajectory. And I suppose the aim is really to get a step trajectory that is looking right, and then use that as the basis for all the other points, including looking back at when the certain works to the A5 would occur. Just on that point, again, potentially it would be useful. I know there was, it was paragraph, my memory is slightly failing me. I think it was 9.69 of the strategic transport assessment, where there was some consideration as to what precise works that covered in terms of the A5, whether it was just phases 1 or 2, which was funded, or a commitment was given to fund through budget, or whether it was including 3 and 4, and that might be useful as well when we're talking about a trajectory tomorrow morning.
We've had a look at that, sir, and we can talk about it in detail tomorrow. But it was just to let you know that we haven't been able to check that with the county council, because the person that we would have checked with isn't available. So
no, sure, but
we'll be able to answer it as much as we possibly can. Okay. And also the paragraph number I think that you're referring to is 9.67 in the Greater Birmingham study, where you questioned about the 1.8%.
Yeah.
And I can deal with that now or would you prefer me to deal with that tomorrow?
Let's deal with that first thing tomorrow. I mean, remind me if I forget, but I think then that gives us 3 of the key things, doesn't it, that I was just seeking clarity on. It gives us the implications of the housing market assessments as they came out. It gives us the timings of the A5 and the implications of that, and then it also gives us what you've just said, the sort of the justification behind the upper limit as the strategic growth study saw it. So
I'm afraid it's just to warn you, sir, that in terms of that I haven't been able to find the absolute source of the information.
No,
that 1.8, but I can point you in the direction of trying to get an answer to that.
Sure. Well, I think, as I said in earlier sessions, I mean the difference between North Warwickshire at 1.8 and other areas is set out in there. So a fair bit can be read into that. But if there was any other information supporting it, that would be great. But no, okay. And I see, so thank you, that's very good to address those issues. Mr. Hodges, I see you've got your hand up.
Thank you, sir. It's one question relating to administrative matters, and you'll see that we have Doug Han and Peter Lever down to speak tomorrow afternoon. I just wanted to make sure that all of the overspill matters from this morning's session, are they down to be covered in tomorrow afternoon's session? Or is there anything on this morning that actually is better placed being discussed in the morning? Because if that's the case, it may be that we need to also bring them in to speak to them in the morning. The reason being, I think that there was some confusion amongst our party as to whether you'd said afternoon or morning for these matters to be discussed in. So anyway.
Yes, I mean, I think what I want to do in the morning is to look at so sorry if this causes any disruption. I see you've got books on the bookshelf behind you now. Sorry, that completely
life has returned. So
completely confused me. So in the morning, I'd like to look at the sort of the points around the stepped trajectory and the delivery assumptions in terms of housing in particular. But then in the afternoon, that's kind of a session to deal with all the points around the things I've asked the council to go away and look at in terms of the main modifications. So just turning back to all the things that we've done, it may be that some of the points that the council will consider, they simply won't have had the time to present a fresh set of main modifications, and that's okay, because as and when there'll be another consultation on the main modifications, but it would be to address, let me see, 2 seconds. If there are any of those points on calculation of Coleshill Hall Hospital, or indeed in relation to MM25, and that's policy LP6, or indeed in MM25, which relates to the meaningful gap, I think probably the right point for them is paragraph 69 of INSP 5B, which is for the afternoon session. So I hope that helps.
Okay, thanks. Yeah. Okay. No problem at all. Thank you.
I mean, it may be, and I'm just saying this because, you know, it's a pretty intensive thing doing a week of hearings, and it may be. I'm not expecting the council to come, you know, with everything all singing, all dancing to that session. But we will talk through the issues. We'll see where we are, and then we'll see where we need to be. But thank you in advance for all the work that you will be doing on that. So thank you. Okay, unless there yes,
sir, would it be possible just to ask for a point of clarification? You said yesterday in the list of things that so I can just quickly go back to it. There was something about any disputes in terms of the trajectory, and I took it that it was any disputes in terms of particular sites.
That's right.
Right. So, and that's mainly to do with, I'm assuming, the Pegasus and other people who have said that particular sites won't come forward at the particular time that we've said so. Is that correct? Yes. Okay, that's fine.
I think that's right. I think where there is a particular dispute, say a piece of enabling infrastructure or a particular constraint, and there is a dispute as to whether that timing will work out. It wasn't to sort of come prepared and say, well, these are the sites we want to talk about. I'll let the discussion go where it goes, but it was just a sort of hopefully a helpful comment that to be aware that those probably will come up in the context of the site allocations discussion. So
that's fine, sir. Thank you.
All right, thank you. Okay, well, it looks like we're there. Thank you very much, everyone. It was very useful. I will then adjourn, and we will come back tomorrow morning, where we'll be discussing various matters, starting off with the trajectory. So, thank you. Okay, we're adjourned.
Thank you, sir.
Thanks, sir.